case against the young man accused of the Boston Marathon bombings heads back to court today, and attorneys for Tsarnaev will be appearing for that status hearing to work out several issues ahead of his upcoming trial. And the case against another friend of Tsarnaev's is wrapping up this week, and Michael Coyne, the dean of the Massachusetts School of Law, is here to talk about that. So the case against Phillipos, the obstruction of justice case, closing arguments are set, and what direction do you think this is going to be made? I mean, we got that surprise witness on behalf of him last week, Michael Dukakis, and did that change things? It could have.
It could have changed things slightly. He's put himself in a position now where he has a chance for a not guilty. I don't think that will be the case. But what we will see in the closing arguments tomorrow is an attempt to create that reasonable doubt, to say he's a good boy from a good family who just smoked far too much marijuana to really be able to know what he was doing and had done. It may be enough to create a reasonable doubt. I don't think so, but that's what his plan is.
Have you ever seen any cases where that was a successful defense, where the attorney said, oh, my client was too high to know what was going on?
No, sometimes you do see the alcohol intoxication and the like, but the fact is, for the most part, the voluntary intoxication or the voluntary consumption of drugs is not likely to be a sufficient excuse for whatever criminal activity you're involved with. What makes it interesting here is what he's saying is that the drugs actually made him so forgetful that he couldn't intentionally lie about his activities. And it's an interesting twist on an old defense that hasn't worked, but I don't expect it to work here either.
All right, let's turn to Tsarnaev, who his attorneys will be in court, but again, he's not going to appear. Why does he not have to go to court every time they have these hearings?
Yeah, it's really just a motion hearing. If there was an arraignment, as it happens early in the process, or even a pretrial conference at the end, you might expect him to come. But he doesn't have to be brought to court for every single motion hearing, and that's what we're looking at today. He's looking for the information from the killings that it's alleged that his brother participated in.
In Waltham 2011.
Correct, and trying to argue that somehow those events link the influence of his brother over him, and he wants to get access to that information, likely to be able to try and spare his life with respect to the death penalty, to argue that my brother was the real maniac here, and I had to go along with them, or at least if I didn't go along, I would have suffered even perhaps a worse consequence. And that's what his argument is. The government says that if his brother was involved in these killings at all, that is simply not relevant to the marathon bombing.
All right, we'll see what happens. Dean of the Massachusetts School of Law, Michael Coyne, thank you. Always great to talk with you.